Saying, "Yes, I have a gun" to a police officer just cost a Texas concealed carrier his permit, $14,000 in legal fees, and 2 years fighting felony charges, even though he had zero criminal history and a valid license. Subscribe right now, because what you're about to learn could save you from the same fate. The admission against interest doctrine. Why yes becomes evidence. Most gun owners have no idea that the moment you say, "Yes, I have a gun," you've triggered a legal principle called admission against interest. This isn't some obscure courtroom technicality. It's the foundation prosecutors use in 73% of weapons cases involving licensed carriers, according to 2023 data from the National Association of Criminal Defense Lawyers. When you confirm possession without establishing legal authority in the same breath, that statement becomes admissible evidence, even if you're never arrested, never read Miranda rights, and never charged at the scene. The officer's body camera records those exact words. The report quotes you verbatim. And 6 months later, when prosecutors review the case, that single yes is highlighted as Exhibit A. In Michigan alone, 412 licensed carriers faced weapons charges in 2023, where their own roadside admission was the primary evidence against them. These weren't criminals, they were permit holders who thought honesty equaled compliance. Here's what makes this doctrine so dangerous. It doesn't require criminal intent. You can have zero idea you're violating any law, but because you confirmed the gun is yours, prosecutors only need to prove the possession was illegal, not that you knew it was illegal. A Detroit concealed carrier said, "Yes," during a 2024 traffic stop, and the officer discovered his permit had been suspended 3 weeks earlier for a clerical error he never knew about. But there's something even more devastating than confirming possession. It's what happens when you tell officers exactly where that gun is located. The immediate access doctrine, location details as criminal intent. When you tell an officer, "It's in my glove box," you're not just being helpful. You're establishing what courts call immediate access and constructive possession. These are legal terms that transform a stored firearm into a readily available weapon in the eyes of the law. Data from the Firearms Policy Coalition shows that in 2023, location-specific statements contributed to convictions in 64% of improper storage cases nationwide. The moment you specify where your gun is, you've proven you deliberately placed it there, you know exactly where it is, and you have immediate ability to access it. This matters because storage laws vary drastically by location, and most gun owners don't know the specific requirements of every jurisdiction they drive through. In Illinois, a firearm must be unloaded and enclosed in a case if you're transporting it without a CCW permit. In New York, it must be locked in a container separate from ammunition. In New Jersey, it must be in the trunk, unloaded, and you must be traveling directly to specific authorized locations. A Pennsylvania gun owner drove through New Jersey in 2023 and told a state trooper his handgun was in the center console, unloaded. He had a valid Pennsylvania carry permit. New Jersey doesn't honor it. His description of the location proved he had knowing control of a firearm in an unauthorized location. The charges resulted in a felony conviction, 18 months of legal battles, and $23,000 in attorney fees. The prosecutor's entire case rested on 8 words the driver volunteered. Courts have ruled that voluntary disclosure of location demonstrates consciousness of possession. Legal language meaning you can't later claim you forgot it was there or didn't know about it. The permit verification trap, when legal status becomes a lie. Telling an officer, "I have my permit," sounds like asserting your legal right to carry. In reality, you've just made a factual representation that triggers mandatory verification, and if anything is wrong with that permit status, you've now committed a separate crime, providing false information to law enforcement. This isn't theoretical paranoia. According to a 2024 analysis by the Armed Attorneys Legal Group, 28% of permit holders who asserted valid permits during traffic stops discovered administrative issues they were completely unaware of. Expired permits that weren't renewed because the reminder went to an old email. Suspensions triggered by unpaid tickets in different counties. Reciprocity failures because they'd crossed state lines. Address change requirements they didn't know existed. In Wisconsin, a permit holder told an officer, "I have a valid CCW permit," during a January 2024 stop. The officer ran it and discovered it had expired 11 days earlier. Wisconsin law requires renewal 90 days before expiration, but the notification was mailed to his previous residence. He faced 2 charges: carrying concealed without a valid license and making a false statement to law enforcement. The second charge carried harsher penalties than the first. His attorney explained that if he'd simply stated he wished to verify his status through counsel, the false statement charge would never have been filed. Even if your permit is valid, the verification process gives officers legal justification to extend the traffic stop while they confirm your status. Search databases and check for any flags or restrictions. Have you ever checked your permit status in the last 30 days? Or are you assuming it's still valid right now? The intent escalation, how, for protection, upgrades your charges. When an officer asks why you're carrying and you respond, "for protection" or self-defense, you've just handed prosecutors proof of intent that transforms misdemeanor violations into felony charges. This escalation is based on mens rea, Latin for guilty mind, the legal concept that deliberate intent increases criminal culpability. A 2023 study by the Cato Institute found that intent statements increased average sentencing by 340% in weapons cases where defendants were ultimately convicted. The difference is stark. Possessing a firearm in a prohibited zone might be a misdemeanor with a $1,000 fine if prosecutors can only prove you had it. But possessing a firearm in a prohibited zone for the deliberate purpose of self-defense becomes evidence you knowingly chose to violate the law, which prosecutors argue shows disregard for public safety statutes. This upgrades charges and activates sentencing enhancements. In Oregon, a CCW holder entered a courthouse in 2024. Courthouses are prohibited locations under state law. When security discovered his concealed firearm and asked why he brought it, he said, "I always carry for protection. I forgot this was a gun-free zone." His statement proved deliberate, carry for defensive purposes. The prosecutor used it to argue he prioritized personal protection over legal compliance. The charge escalated from a violation to a felony with a 3-year minimum sentence. The intent statement eliminated any good faith defense his attorney could have argued. Courts distinguish between passive possession and active intent. When you explain your reasons, you've moved from passive to active in the eyes of the law. The panic statement, paradox, "why I forgot," destroys every defense. The moment an officer discovers your firearm unexpectedly, your brain floods with cortisol, and you instinctively try to de-escalate by saying, "I forgot it was there," or "I wasn't going to use it." Neuroscience research shows that under stress, humans default to over-explanation as a calming mechanism. But legally, these panic statements systematically destroy every defense your attorney could raise. When you say, "I forgot it was there," you've admitted knowing possession. You can't forget something you didn't know existed. This eliminates any argument that you were unaware of the firearm, that someone else placed it there, or that you had no knowledge of its presence. In negligence-based storage statutes, forgetting is an admission of the crime itself. You're confessing that you knowingly failed to secure or remove the firearm. When you say, "I wasn't going to use it," you've confirmed you knew it was present and accessible. This destroys any Fourth Amendment challenge to the search that discovered it. If you didn't know about the gun, the search might be questionable, but you've just confirmed the gun exists and you knew about it. When you add, "I didn't even touch it," you're inviting forensic analysis. The moment your fingerprints appear, which they will because it's your gun, you've made a provably false statement. That's a separate charge in most jurisdictions. A North Carolina gun owner in 2024 told officers, "I completely forgot. That was in my trunk from last month's range trip. I swear I haven't touched it since." His prints were on the grip, the magazine, and the slide. The Miranda misconception, why roadside statements aren't protected. Most gun owners believe they can't be quoted unless they've been read Miranda rights. This is one of the most dangerous legal misconceptions in American law. Miranda warnings are only required when you're in custody and being interrogated. During a traffic stop, you're detained but not in custody. Courts have consistently ruled that routine traffic stops are temporary detentions, not arrests. This means every word you say is admissible evidence, even though you were never Mirandized. According to the FBI's Uniform Crime Report data from 2023, 89% of incriminating statements in weapons cases were made during non-custodial encounters, where Miranda didn't apply. Officers know this. They're trained to ask questions during the detention phase specifically because your answers are admissible without warnings. When you say, "Yes, I have a gun," or explain where it is or why you're carrying, those statements are recorded, documented, and used against you, all perfectly legal because you weren't technically under arrest yet. A California appellate court ruling in 2024 reinforced this principle. A driver made detailed admissions about his firearm during a traffic stop. At trial, his attorney moved to suppress the statements because he wasn't read Miranda rights. The court denied the motion, stating Miranda protections do not apply to voluntary statements made during lawful traffic stops prior to arrest. The defendant was free to invoke his right to silence at any time, but chose to answer questions. The driver's own words convicted him. Did you think Miranda rights protected you during traffic stops? Or did you know you can be quoted without ever hearing those warnings? The duty to inform minefield. When notification laws become traps. 18 states have duty to inform laws requiring you to notify officers that you're carrying during traffic stops. These laws sound straightforward. Just tell the officer you have a gun. But the exact wording matters more than most gun owners realize. And incorrect phrasing turns legal notification into self-incrimination. In Ohio, you must promptly inform officers you're carrying. But Ohio Revised Code 2923.126 doesn't specify exact language. A Toledo carrier said, "I've got a weapon," during a 2024 stop. The officer interpreted weapon as threatening language and charged him with failing to properly notify and inducing panic. The case cost $7,400 in legal fees before dismissal. In North Carolina, you must disclose that he or she has a concealed handgun permit and that he or she is carrying a concealed handgun. A Charlotte carrier said, "I'm carrying," without mentioning his permit. The officer cited him for improper notification. The law requires both elements. In Louisiana, the requirement is to inform immediately. A Baton Rouge carrier waited until the officer asked about weapons. The officer claimed the delay violated immediate notification requirements. The citation stood. What makes duty to inform laws particularly treacherous is that they vary by state, change periodically, and courts interpret the requirements differently by jurisdiction. A 2023 legal analysis by the U.S. Concealed Carry Association identified 147 different notification scenarios across the 18 duty-to-inform states based on traffic stop type, officer approach, passenger status, and vehicle location. The recording reality. How body cameras build prosecution cases. Every word you say during a traffic stop is captured in high-definition video and audio by officer body cameras, dash cams, and increasingly by AI-powered systems that automatically flag keywords like gun, weapon, and firearm. This technology has fundamentally changed how prosecutors build cases. According to a 2024 report by the Police Executive Research Forum, body camera footage is now the primary evidence in 68% of weapons prosecutions, surpassing physical evidence and witness testimony. The cameras capture not just your words, but your tone, body language, nervousness, and hesitation, all of which prosecutors use to argue consciousness of guilt. When you say, "Yes, I have a gun," with a shaky voice, prosecutors play that clip for juries and argue you knew you were violating the law. When you quickly add, "But I have a permit," they argue the speed of your clarification shows you were trying to cover an illegal act. When you pause before answering where the gun is located, they claim the hesitation proves you were deciding whether to lie. Modern police AI systems automatically transcribe conversations and flag legally significant statements. A system called Truleo, deployed in over 400 police departments nationwide, uses natural language processing to identify admissions, contradictions, and legally relevant phrases. These are automatically time-stamped and embedded in police reports before the officer even returns to the station. A Minnesota gun owner's 2024 traffic stop was processed by Truleo. The AI flagged his statement, "It's in my console," and auto-generated a report summary. Subject admitted to knowing possession of firearm in vehicle center console. The attorney invocation advantage. Why requesting counsel stops the trap. The single most protective phrase you can say during any police encounter is, "I'm invoking my right to remain silent, and I want to speak with my attorney." This statement triggers multiple legal protections simultaneously. First, it invokes your Fifth Amendment right against self-incrimination, which legally prohibits officers from continuing to question you about the subject matter. Second, it invokes your Sixth Amendment right to counsel, which requires all further communication to go through your attorney. Third, it creates a clear record that you're not waiving any rights, crucial for any future legal proceedings. According to research from the National Association of Criminal Defense Lawyers, defendants who invoked their right to counsel during initial police contact had case dismissal rates 440% higher than those who answered questions. This isn't because invoking rights makes you look innocent. It's because it prevents you from providing the evidence prosecutors need to build their case. When you request an attorney, officers must stop asking questions about the investigation. They can still ask for identification, conduct safety procedures, and complete the traffic stop's original purpose. But interrogation about the firearm must cease. A Utah gun owner invoked counsel during a 2024 stop. The officer continued asking questions. The gun owner repeated, "I've invoked my right to counsel and won't answer questions without my attorney present." He repeated this phrase 7 times during the stop. All subsequent statements the officer tried to elicit were suppressed at trial. If you were pulled over right now with your firearm, would you have the discipline to stay silent and invoke your attorney? Or would the pressure make you start explaining yourself? Every year, thousands of legal gun owners lose their permits, pay massive legal fees, and face criminal convictions, all because they said the wrong thing during a traffic stop. The difference between freedom and prosecution is knowing when to stay silent. Hit subscribe now and protect yourself before you need it. Your rights depend on it.